Good afternoon. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. This Zoom meeting and YouTube live stream event will include the agenda of the Committee on Housing at 1:00 p.m. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business at 2:15 today in this room, 225, and a public notice will be posted on the legislature's website. For all those participating remotely, testifier audio will be muted and video disabled until shortly before it is your turn to testify. Okay, so again, this is the 1 p.m. agenda of the Committee on Housing. I'd like to welcome our committee members, Senators Favela and Moriwaki. It's both a decision-making and a hearing, members. On March 15th, we had held a hearing on this measure, House Bill 1917 HD1, moved to the votes. I'm not sure what the committee's wish will be, but just to summarize for everyone briefly, there's this project, the Front Street Apartments, that are currently affordable. They're located in Lahaina, Maui. The owner of the project is in court to try to remove the affordability restrictions and to therefore bring the project up to market price. The tenants are in court to prevent that from happening and are trying to keep the project affordable until 2051. In the course of the litigation, as we know, which is uncertain, the court might find that these units should go to market and that their affordability restriction goes away, in which case the tenants would be kicked out, and or if the state were to buy the interest, it would be much more expensive for the state to do so. And so the posted SD1 today offers a solution in which the state would give rental housing revolving fund and private activity bonds to an unspecified private developer to start a new 75-year affordability period for this project. Okay, so I've tried to make it as clear as possible. We'll start now with the testimony.
Call for the vote for reconsideration before you start the testimony.
Are we required to?
It's recommended policy.
Do you feel that you have enough information to do the reconsideration? Okay. All right, so we'll move forward now with motion to reconsider. So after further consideration and discussion, as I've just discussed, I'd like to consider amendments that are substantively different from those that we adopted on March 15th. Therefore, the purpose of this meeting is to reconsider the previous action taken by the committee on this measure, hear public testimony on a proposed draft of the measure, then take a new vote on a new recommendation. We will begin with a vote on the reconsideration. Chair recommends reconsideration of the committee's previous action on House Bill 1917. Chair votes aye.
Chair votes aye. Senator Kanuha excused. Senator Moriwaki aye. Senator Rhodes excused. Senator Favela.
Aye.
The recommendation is adopted.
Okay, thank you. Okay, so now we are considering the posted SD1, and we have several testifiers on this measure. The first is HHFDC in opposition.
Hello, good afternoon, Chair and members of the committee. Denise Matsubar for HHFDC. I'd like to begin by saying we really want to work to preserve affordable housing, and our opposition has nothing to do with that. What we're opposed to is the fact that the judge has already ruled on this project to remain affordable. And our concern and our fiduciary duty in terms of being good stewards of the public dollars, and in this case, the bond cap as well, that because the judge has already ruled for the project to remain affordable, and there's 30 more years of affordability left on the project, And we have 28 applications for 2,700 units, nearly 2,000 of which are new units, asking for rental housing revolving funds and bond cap. The requests for bond cap are close to $750 million, and the request for rental housing revolving funds is around $356 million. So every project is important, and we are just raising the issue that the project is already affordable. The judge has ruled that, and there's ongoing litigation. Yes, we understand. We want to negotiate a ground lease. We want to be able to move forward, but we also have to be good stewards of the public trust, the bond capped, and the rental housing revolving funds. Thank you very much for the opportunity to testify.
Thank you very much, Director. So what happens, so as I understand it, Director, the lawsuit is now on appeal. What would happen if a court found that the units did not have to remain affordable, that they could all go to market in the future?
Then it would go, I don't know exactly, Senator. I would have to actually consult with the AGs and find out what are the legal ramifications after that. But I would imagine that if it goes to market, then it goes to market. But the likelihood of that happening, you know, I don't believe that there's going to be a strong chance of that, given the IRS code and the extended use period that is already noted in Section 42 of the IRS code.
Chair, I have a question
Senator
on that.
Moriwaki.
So Denise, thanks. So when was this decision rendered, and is it being appealed or not? I guess we want to know how solid is that decision.
Yeah, I don't know exactly when it was Judge Otake, I know, and I can't remember if it was in 2020 or 2021. Could I ask if we could allow Dean Minakami from our development branch, who has been working with the Attorney Generals on this, to speak if he has any information? Would that be allowable, Senators?
Go ahead.
Sure, Senators. Regarding the date of the order, Judge Otake's order is dated August 12th, 2020.
Has it been appealed?
Yes, it is under appeal presently.
I think the appeal was filed early this year, if I'm not mistaken.
So you've looked at this proposed language, and given the still yet uncertainty, even if we have a court ruling and you think that it's going to stand, the concern is that if it doesn't, what would be the ramifications if we allow this to go forward and it is appealed and the cost goes back to market, or goes to market prices. And we just, don't want to risk tenants being out on the street.
Yes, I can appreciate that concern, Senator Moriwaki. I don't want to guess how the judge would rule, but we have a strong belief that the provisions in the IRS code is going to prevail under the extended use period for qualified contracts, and that they will stay the order that the project should remain affordable. That's as much as we have to say about it. We have a strong belief that the judge will look at the IRS code and see the extended use period and recognize that is there for a reason.
So in this proposed draft, which allows you basically to take back the lease and find a developer who could develop or maintain or improve the properties that are the property now there. What is the objection to doing that? Is it intruding into anything if you did that?
Sorry, Senator Moriwaki. The question is if we were to do what?
If you were to follow what's in this proposed draft, which is to basically take back the lease and find another developer for this property, so that it would negate the lessee currently and find another lessee.
And your question is?
I mean, that's what this proposal recommends. And so you're saying you're opposed to it because it's, you already have a ruling. The question is, given that, and let's say, let's put that aside, what is the problem with the content of this bill in terms of getting a lease to another developer who can keep the properties affordable?
So my concern with that, and I want to say that, we recognize it is really the desire of this committee on what you want to do, but just from a fiduciary standpoint of the state, it circumvents the competitive review process of the QAP, the Qualified Allocation Plan, which is the criteria established for review of any kind of LIHTC request. And one of the things I've learned through working with the legislature and developers is that this competitive review process is there to ensure that the most efficient use of the resources are made for the benefit of all. So that's one thing, because otherwise I have 28 applications for financing right now. You'd have 28 different projects or a handful of developers asking you for earmarks. And would you be able to do earmarks for all of them? And some of these projects are new construction. So you're going to be actually adding inventory to affordable housing. There may be projects in the cycle that are in really bad disrepair with not 30 years of affordability left like this one. Some may have much fewer years. So all of these projects are important. They're all important for affordable housing. We have the tough job of trying to screen through everything. And these applications comes in thick binders, like 3 or 4 of them at a time. That's one project to do a very intense and thorough review. So, that's just from our standpoint and our perspective is we have to look at things in totality and in a competitive fashion for limited resources. Number one, and first and foremost, is the bond cap. Because right now I'm $18 million short and I haven't even started my financing cycle yet. So every $1 million of bond cap matters. It's a difference between a project that really needs it and a project that may have not needed it as much. So I couldn't say without looking at everything. And we have staff that has to carefully analyze all of this. So if you ask me, do I want to do this? Of course I do. Of course I want to support these people. I want to support people in every district that really need it. I wish we could, but here I am with this very difficult task of trying to make sure that the best, most efficient use of the state's limited resource is done. So thank you.
Oh, but this Front Street property has been coming before us year after year. So it seems that we should be doing something about it rather than just, waiting. I don't know what, if we didn't do something like this, what would happen to the property? You just keep it going until what?
I think it has to run its course through the legal channel, and then we have to negotiate the ground lease. So, other than that, you can make a determination on how you want to use the resource. We just have to do it in the most efficient fashion, thinking of all projects that are asking. We don't have the luxury of just picking and choosing. We have to follow strict criteria. So that's our obligation. The other thing is that there are other projects coming up in the area as well. And if I can turn to our development branch chief, he can tell you there's 2 other affordable projects coming up in the area in Lahaina as well. Dean?
Yes, that's correct. In the Lahaina area, there are 2 projects. There's the Kaia'ulu Kupu'ohi project, which has 89 units, all affordable to rental. It's a rental project, affordable to households 60% below EMI. And that one is coming online, should be this year. And there's the Kaia'ulu Kukuia project, also known as the Calvi Street Apartments project, also affordable to households at 60% AMI below. It's a 200-unit project, and that should be completed in 2025.
So I'm not getting what you plan to do then with this property if we don't do anything. But what happens to this property, and how many tenants do you have in this?
Fresh Street Apartment has 141 units.
So I think that's the question. What do you plan to do with this property if we don't do something like this proposal?
Well, we intend to hopefully prevail and negotiate the ground lease and move forward.
Move forward being what?
Negotiate the ground lease. It remains affordable so that we can be done with the litigation and then cleanly negotiate the ground lease with a clean appraisal and move forward.
Yeah, I would also add that the state expended $16 million to purchase the leased fee interest. So we presently receive about $300,000 a year in lease rent. So it was a substantial investment by the state to purchase the lease fee interest. And I think that is something that we should negotiate with the Fresh Street Apartments, whether it should be $1 a year or somewhere between the current lease rent and $1 a year. By setting it at $1 a year, that will substantially limit our negotiating ability.
Okay, all right. Well, we can move on then. Senator Favela, any questions? Okay, we'll move on. Thank you very much. Next testifier is Department of Budget and Finance with comments, followed by HOU Group in support. You're on, Makani.
Oh, okay. Good morning or good afternoon, Chair, members of the committee. My name is Makani Maeva. I'm an affordable housing developer with the HOU Group. I think you've heard what the problem is here with Front Street Apartments. Built in 1999, the original developer asked to be released of the affordable housing obligations, was subsequently released from their affordable housing obligations by HHFDC, and thereafter ensued a lawsuit. For 3.5 years, the tenants there have been were in limbo, a state of housing insecurity, without any knowledge of what would happen to their housing. In nearly 2 years ago, in August of 2020, the judge ruled that the affordable housing obligations should be reinstated. However, they're not currently reinstated. The seller has agreed to enter into a contract to acquire, for HOU Group to acquire Front Street Apartments. The acquisition price is about $193,000 a unit. So it's extremely reasonable given the state of the market and the location and the value of these units within the Lahaina market. The developer, the original developer, the seller is, however, continues to be involved in this lawsuit. So it's been another 1.5 years for the tenants, so 5 years. And in July of 2022, oral arguments are scheduled in front of the Ninth Circuit. So I understand that the job is difficult and allocation of resources is difficult, but the seller is confident that they will also be victorious in their oral arguments, which would be decided in about October, according to the attorneys. So in about October of 2022, we will come to a place where we have either an affordable housing project, which now has absolutely no affordability restrictions and now will be market, or we'll have an affordable housing project where the affordable housing restrictions have been reinstated. And now HHFDC still, the seller, one of the terms of the lawsuit was that the existing developer needs to sell, can no longer be own the property. So HHFDC will then have to negotiate, as we've heard, lease rent and some ability to acquire. This developer does not want to continue to own affordable housing. I am an affordable housing developer. This is a solution. We could acquire it, we could renovate it. We will agree to 75 years of affordable housing at rental rates of 50 and 60% of the median income. The solution is there. It is very difficult to say what projects are more valuable than other projects. It is very difficult. We have scarce resources for affordable housing. As I've said, I've been doing it for 27 years. So this is not easy, I know, for Denise and for the staff at HHFDC. But we are not building new units at $200,000 a unit. It's just the fact of the matter, at $193,000 a unit. So the price just goes up and up and up. I've been in contract for 3 years. The seller has not increased the purchase price. We've applied to HHFDC. And again, it's a very competitive process, but we're trying to come up with an expeditious solution. I think it would be penny wise and pound foolish to not take advantage of a solution that we could offer. So I'm available for any questions. It is difficult, as Denise says, she's oversubscribed for these tax exempt bonds and for rental housing revolving fund. I will say that the County of Maui recognizes that this is important and has recently allocated $6 million towards the acquisition of this property and renovations. And so we are bringing together groups to try to come up with a solution, and we're asking for your help to also assist us.
Thank you. At this time, we'd like to welcome committee member Carl Rhodes. Members, any questions?
I do.
Senator Moriwaki.
Thank you. Hi, Maeva. You bring up a really good solution, collaborative solution. I'm just wondering, so everybody involved in this solution is at the table in agreement, the developer, the owner. You say that the seller is still in court, but is the seller at the table as well, so that this would be a resolution of all parties involved with the transfer of the rights, I guess, in terms of the land and your development?
Yes, that's correct. The seller is an active and willing participant in this solution and still continues to be under contract with us. And they believe and support affordable housing. They just are not the right owners of the affordable housing project. So they are here and agreeable, and yes, they will drop the lawsuit. Obviously, there won't need to be any lawsuit, right? They will have sold. So they will drop the lawsuit. The tenants will actually receive what they'd like to receive. And we will have, for the next 75 years, affordable housing here. We will also be making an investment into the renovations because it's one thing to acquire it, but the property needs a bit of renovation. It doesn't need a heap. It's 22 years old, but everybody knows after 22 years, if you can do some of the major things, if you can do the paint, you can make sure the drainage is correct, that the roof works, then you avoid a real escalation and deterioration of an asset. So it's the right time to make a reinvestment and make sure it continues to be really safe, clean, decent, affordable housing.
So you're saying that the seller will release and drop the appeal and basically sell you the remainder of the lease, or it goes back to HHFDC to then work through the lease with you, or is it getting the lease directly from the seller, the current lessee?
Well, we will. That's the reason the lease terms are in there. HHFTC routinely offers leases $1 a year, as does do counties, $1 a year for 75 years in order to advance affordable housing. So that was why this was one of the suggestions for this legislation was, with that lease term. I mean, obviously, if HHFDC wants to make $400,000 a year off of lease payments, there's no affordable housing project that can afford to pay that. In fact, the reason the current seller is paying that to HHFDC is because, there are a few 15% or so are market rate units. So, and I'm not trying to minimize how difficult it is for HHFDC. It's a hard position.
So can we have HHFDC back on?
Why don't we finish with the
I'm
testifiers
sorry.
and then
Okay,
we
go ahead.
can do so. Any further questions for AHE Group? Okay, if not, thank you very much. We'll move forward to Hawaii Appleseed in support, followed by Affordable Housing and Economic Development Foundation in support, followed by Tamara Paulton in support.
Aloha, Senator Chang, Senator Favela, Senator Moriwaki, and Senator Rhodes. Thank you so much for your reconsideration. I too can appreciate the position that you're in, as well as HHFDC. I'm the council member that lives in Lahaina. I'm in Lahaina right now, and I'm just, we really would like you to take this opportunity. I'm sure it's going on in the places that you live as well, but we have a big housing crisis. My office is assisting many newly homeless, elderly members of our community in their 80s and beyond, some of them working homeless recently. We assisted a 82-year-old that works at Safeway who had been living in his car for 50 days to get into a shelter. And, I know it's new projects versus keeping projects, but these people will not have any place to go. We don't have capacity for 143 unsheltered people. And the parent company of the building owner, they specialize in the commodification of housing. And they're doing it currently all over the continent. And they'd like to do it here. And we're going into budget, and I'm committed to getting that $6 million for the AHE Group. And I think this is a good opportunity to partner and to keep our people out of becoming homeless. I don't know if it means a lot to you, but I can see all the people that live their faces. My kids play with those kids at the Boys and Girls Club. And we're just asking for your help. As Senator Moriwaki says, this item comes up every year, and every year the residents that live there are in uncertain housing. And as they're in that uncertain housing, the housing crisis is getting worse and worse. People are paying in Lahaina $2,200 for one room, utilities not included. So, there are no other options. These people will be homeless if the appeal goes through. So just really asking for your help. Thank you.
Thank you. Our next testifier is Chair Alice Lee, Maui County Council, in support. And our final testifier is Barbara Henning in support. Okay, that brings us to the end of the list of the registered testifiers. Is there anyone else wishing to testify on House Bill 1917? Okay, if not, we can go back to discussion, Senator. I know you had questions, Senator Moriwaki, for HHFDC.
To HHFDC. Denise, this seems like a really good collaborative effort from the county and the state, as well as the developer and the release from the appeal on this case so that we can end this long unnecessary journey. Is there a way that we can amend this bill so that it addresses some of the concerns that you have so that we can move this along, and perhaps you have some time to work with AG, Budget and Finance, to see how we might accommodate this proposal?
Sure, we'd be willing to work at that, Senator.
Thank you. Thank you, Chair. I think we try to move it through.
Members, any further questions or discussion?
So just to follow up with Denise, so do you have any language that would address some of your concerns that we could put in this bill, or we could pass this bill out and you could work on it to the next committee, which is when? Is it when? But if or if we could put in the committee report so we can address it with BNF and AG.
We don't have any language offhand, but we will certainly work with our Attorney General on it.
Okay,
Towards.
thank you. Maybe Chair, just put it in the committee report that they would look at this proposal with the AG and the Budget and Finance.
Well, one specific question that was already raised was the nature of the lease rent. We just heard testifier say that $1 a year was typical, but you're estimating that about $10,000 or $20,000 per year would be in line with the administrative costs. Director, can you explain the discrepancy?
So what Makani Maeva is referring to is the old practice of $1 a year, and what the staff has done is done a reassessment of the cost involved to administer these ground leases, and they came up with an assessment, presented it to the board for approval, and I forget what month it was, but there's a minimum threshold now just to cover our costs to maintain these ground leases, and I believe it ran between $10,000 and $20,000, but I have to go back and double check that. But if there's a way we could at least cover our cost to administer the ground lease, that would be appreciated.
Thank you. I'll take one more question for AHE Group. Is AHE Group still with us?
I'm still here. Can you hear me?
Okay, great. So you just heard what the director said about the costs with respect to the lease. The SD1, the proposed SD1 does say $1 a year, but they're asking for the coverage of their administrative costs. What do you have to say about that?
I think that's Denise is correct. I haven't seen the new lease policy, but I did attend that board meeting. I wasn't aware that it had been incorporated or that the lease terms had been solidified. But yes, I think we reviewed that and had no opposition when it came to the board. So that's also acceptable. Yeah.
So would it be acceptable to, at least for now, put in a blank amount for the ground lease?
Or ground lease, could we put the ground lease terms adopted by the HHFDC board?
Okay.
Yeah.
Any further questions or discussion, members? Okay. If not, we'll go into recess and return with decision making. Thank you.
Thank you.
Okay, good afternoon. We're back from our recess, and having conferred, the Committee on Housing will be recommending passage of this measure with amendments. House Bill 1917 HD1. First of all, we'll take the posted proposed SD1. We'll also add in an amendment that the ground lease amount will be not $1, but as adopted by the HHFDC board. Senator Moriwaki also noted HHFDC's willingness to find consensus language with AG and with other relevant agencies. And we will note that in the committee report. Senator Moriwaki, do you want to restate what you wanted to include in the committee report?
Sure. That HHFDC will look at this proposal and work with Budget and Finance and with Attorney General and other agencies to see how we can come up with a good resolution.
Thank you, Senator. Okay, so any discussion or questions, members? Okay, so I'll just note as the chair, this is a difficult issue. We have 100-something units of tenants who will have nowhere to go if the litigation finds that the units are not affordable. It's certainly the chair's wish that this matter be resolved as soon as possible instead of gambling that the litigation goes our way. And this SD1 is our hope that we are able to bring some certainty to the tenants, to the entire Maui community. So again, so the recommendation of the chair is to pass HB 1917 HD1 with amendments, and the chair votes aye.
Senator Kanuha, excuse. Senator Moriwaki, aye. Senator Rhodes.
Aye.
Senator Favela.
Aye.
Chair, your recommendation is adopted.
Thank you very much, members. Really appreciate your patience and willingness to engage on this issue, and there being no further business, this committee is adjourned.